Today on LawNext, a conversation with Natalie Knowlton. For 14 years, she's been at the Institute for the Advancement of the American Legal System, or ILS for short, most recently as Director of Special Projects. And now she is launching something new, Access to Justice Ventures, a think tank devoted to reinventing the legal system to provide justice for all people by eliminating systemic barriers. She continues to serve as an advisor to ILS on regulatory innovation. Earlier this year, Natalie was named to the 2022 Women of Legal Tech by the ABA's Legal Technology Resource Center. This is Bob Ambrogin, and you are listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before we get to my conversation with Natalie, please take a moment to learn about the sponsors who support LawNext. Case, the most specialized legal case management solution for workers' compensation, employment and labor, and insurance defense firms, gives you unprecedented productivity. Now you can save even more time through streamlined online payments with Meris Pay. The in-house payment processor provides an easy, compliant way to get paid faster without the need for third-party applications or fees. Case's native features, such as automated email and document management, time tracking and billing, and online payment reconciliation, are designed to fit right into your legal practice. To learn more about how Case can simplify your practice, check them out online at meriscase.com. That's MERUSCASE.com. Now, on to my interview with Natalie Knowlton. Natalie, welcome to LawNext.
Thank you. Thank you so much for having me. It's an honor to be here.
It's an honor to talk to you, and it's so good to see you. Haven't had a chance to see you in a while now, obviously, as we haven't seen anybody in a while, it seems like. But as we get back on the conference circuit, it's good to get back and see you. And congratulations on your new venture.
Thank you.
I want to talk a little bit more about it, of course. But before we talk about what you're now doing and doing next, I thought it would be useful to maybe talk a little bit about what you have been doing, particularly at ILS. So if we could start there by asking, what is ILS and what were you doing there?
Sure. So ILS is the Institute for the Advancement of the American Legal System, and it's a nonprofit research center located at the University of Denver. However, we are nationwide in scope. And ILS was founded about over 15 years ago now by a former Colorado Supreme Court Justice, Rebecca Love Corliss. And Justice Corliss thought that she could make more of an impact on the justice system at scale off the bench than on the bench. So she started this institute and we were off and running. So ILS has a number of focus areas: civil justice reform, family justice reform, legal education, and legal profession reform. And that's where the regulatory issues come in that I've been working on quite a bit.
Yeah. And you were also working on the family issues as well. Is that right? Do I have that
That's right. Yes. I led our work in family justice reform.
Yeah. And you've been working on the regulatory issues. So what's been the nature of the work that you specifically have been doing there?
So I do a lot of empirical research, qualitative empirical research, supported by our research director and our research department. I do advocacy. So on any given day, I'm working with the courts to advocate for policy changes, particularly in the family law arena. I'm in the self-help field. I've done research on self-represented litigants and self-help and how self-help can be leveraged to better serve self-represented litigants. So it's a really wide variety of work, but ILS is data-driven. That's where I really cut my teeth. So evidence and data are very important to me in anything that I work on, whether it's prime research or advocacy.
That's heresy in law, isn't it? We don't need no stick in data. We know what we're doing.
That's correct. That is correct. That's what we hear.
Yeah. So, how do you go about doing that? How do you, what kinds of things are you looking at and how do you compile data about those things?
So a number of different ways. We do some docket research to understand what case management systems look like, to understand how cases flow through the system. A study that I did in particular, along with the National Center for State Courts and the National Council for Juvenile and Family Court Judges, explored 11 urban family courts, looking at the level of self-representation in the cases, looking at whether the cases were contested or non-contested, looking at whether the contested nature of the case impacted the date to resolution. So that's one way that we can use quantitative data to figure out what the landscape of particular case types looks like through the system. And then qualitative data we've used in a number of ways, talking, for example, to judges, interviewing one-on-one about case management practices. And then more recently at ISLES and the work that I've led recently, looking to connect directly with self-represented litigants about what their experience is in the process. So not just what they encountered in terms of obstacles and challenges, but how it made them feel and how it impacted their lives. I think that's a piece that is often missing. We don't think about the impact on the human life that going through the legal system can have on people. So trying to bring deep empathy to the legal consumer through qualitative research.
I know that a few years back, I interviewed Jim Greiner at Harvard's
Access to Justice
program,
yes.
Where, again, they're trying to do empirical research into the justice system. And one story he talked about always kind of stuck with me because it was an incidence in which when you kind of looked at the data, it didn't necessarily play out to show what everybody thought it would play out to show, which I think was in a particular case involving housing court where self-represented litigants actually fared better than those who went in with a lawyer of the day program or something like that. And I don't know if that followed through in subsequent research, but I just remember that conversation. I'm wondering, for you, are there examples like that where you've discovered through your research that the way things actually aren't the way we all think they are?
Yes, I'll give you the one primary one that I hear all the time, and that's that cases with self-represented litigants take longer than cases with attorneys. You hear that all the time from lawyers going through the system. You hear that from judges too. And the issue with those perspectives is they're only getting a small snippet of the case. But actually, empirical research that ISLES and others have done shows that lawyers take longer in a case because they understand the procedural mechanisms to engage and when to engage them. Self-represented litigants, on the other hand, don't often understand how to move a case through the process and use those procedural mechanisms. So data shows that they actually take a less amount of time when there are parties that are self-represented than with a lawyer. But it's very common to hear the opposite from people in the system.
Yeah, that's really interesting. And although, but isn't a flip side of that maybe they consume more sort of out-of-court resources, like more clerk time, or they don't know, they're constantly going in and asking questions because they don't know what to do, or that sort of thing?
That could be. The research that I have seen has not looked specifically at that, but certainly in courts where there are programs outside of the courtroom that give self-represented litigants access to legal information and in some instances help, that they are engaging court resources. But this is particular looking at the start and end date of a legal matter and how long that takes. How
did you personally start down this road of having this working in this area of researching the legal and the justice system?
I would say I did a lot of falling into opportunities. I was
That's the story of my life.
Right. It's a good story. When I started law school, I was one of those rare law students that knew I never wanted to practice law. I never had a desire to practice law. I went instead as a complement to international affairs master's. I wanted to work in systemic reform at that time at the international level. So I spent a bit of time with the United Nations doing human rights and humanitarian law issues. And then I stumbled into this small little research institute that at the time was set up in a card table in the Women's College on the University of Denver campus. And it was dedicated to research, writing the things that I love and the things that I think I have some skill in at times. And it was a new type of human rights that I had not really thought about because nobody teaches you in law school, or at least they didn't when I went to law school, about the inequities in the justice system. So I immediately gravitated to the access to justice work that ISLES was doing. And then I became, in a word, radicalized once I started working on self-represented litigant issues. years, I was horrified at what people were experiencing and started wondering why this had to be this way, and really became a dedicated advocate for access to justice, access to legal services. I distinguish them as two different things, but that's really where I found my passion.
Yeah. How do you distinguish those? What are they? How does access to justice different from access to legal services?
So I view access to justice broadly from an ecosystem level that can include all kinds of dispute resolution mechanisms that have nothing to do with lawyers, legal services, or even courts. On the other hand, access to legal services is where a lot of the regulatory work is looking. How do you provide legal services? So legal services are a core piece of access to justice to me, but I'm looking at the broader ecosystem level. And I don't want to limit my work just to legal services, because I think that will reduce the number of opportunities that are innovative and new for people in the system to not leverage what we consider now existing legal services.
So when we talk about the justice gap in this country, are you talking about the access to justice or access to legal services?
I'm talking about access to justice.
Yeah.
I'm talking about that broadly. So including the knowledge gap in that, including access to community resources, community empowerment. I know Matt Burnett is doing a lot on community empowerment and legal empowerment. So I mean the broad array of issues. And I also, just because I have your time, I view access to justice as a full It's a full gap that encompasses not only low and no income individuals, but also the highest Fortune 50 companies. Access to justice is a round, huge, what did I use to describe it in a slide recently? An ice cream sandwich. So at the top, you have the high end Fortune 50, Fortune 500 companies. They have access to justice legal issues. And we work on that at ISLES a bit, looking at e-discovery and discovery and pleadings and how the system can be better suited to fit and provide access for those large companies. Then at the bottom tier of that ice cream sandwich, you have low income, no income, the subsidized legal services. You have innovation happening on both ends of that ice cream sandwich. And in the middle are a bunch of people, businesses who don't have access to the things that they need to achieve justice, whatever justice means for them, in court or out of court. So that's my ice cream sandwich access to justice.
Yeah, but I mean that the implications for that top layer and that bottom layer are vastly different, aren't they?
Yes, they are vastly different, but some of the issues are the same. And so I think we do a disservice by saying that corporate America doesn't deserve access to justice. I choose to work within a certain piece of that ice cream sandwich, and others in the B2B space and legal innovation space are doing a lot of work in that top tier. So we just need everybody working on it all at once to really move things forward in that 100% access category.
Yeah. But, the numbers that get thrown around of the, whatever, 80% or so of people who have legal issues or aren't able to get access to some kind of help with those legal issues, those are generally referring to people who are not able to access legal services, not the corporate people, not the enterprise people, but people who, because of income or geography or personal circumstances or whatever, or language or whatever it might be, are not able to access legal services, right?
Correct.
Yeah.
Yes. Yeah, the 80% stat, which I know has been thrown around and is sometimes taken out of context, but most of the justice needs studies in the U.S., I think it's changing a bit with the last LSC study, and ISLES did a study recently, but most legal needs studies focus on low-income populations to target the subsidized legal services market. But when you're looking at someone who makes $34,000 or whatever that federal poverty line limit is, then someone who makes $1,000 more than that, they're not demonstrably richer than those folks who can get subsidized legal services. So I do think it's a poor way to measure the broad access to justice issue just by looking at low income individuals and their justice needs. Although I certainly understand why we do that. Yeah.
And I know I've talked to Rebecca Sandifer on this show, who I think is someone else who's kind of looking at this issue very broadly in terms of not just, as you would say, not just access to legal services, but access to information or a broad range of, might even be social services or something, depending on what the circumstances are, but there are legal problems that need a range of kinds of help. And I suppose people don't even necessarily know to characterize them as legal problems. They just know that they have a problem and they need help with it. So I want to come back to some of these issues if we have time, but I wanted to ask you now about to kind of shift to what you're doing now. And well, let's start with that. So what are you launching now and why are you doing this?
Okay, so Zach Demiola and I are launching Access to Justice Ventures, and Zach and I worked together for a long time at ISLES on regulatory issues, and this is kind of an offshoot of our work there. We're playing the long game with Access to Justice Ventures, so we first are looking at the need to build the regulatory structure that will enable a real ecosystem and environment for innovators and entrepreneurs to build in the justice tech and legal tech space. So our first step is going to be to educate on the research that we have available to us in a way that is easily accessible to people. A lot of times these studies live behind PDFs or academic paywalls, and we want to be able to talk about the research that we have and why it's important. So we also want to be able to create opportunities for people to get engaged. And you hear this a lot in the bar exam, particularly on Twitter, the bar conversation. How do young lawyers, how do law students get involved in efforts to reform the bar exam? The same question is asked often in the legal regulatory space. So what does it look like for someone to take up the mantle or to get involved in a state's effort? Zach and I know that very well. We've spent our careers for the last several years doing that. So we want to be able to first provide the information that people need to speak knowledgeably at these state level efforts, and then provide that opportunity for them to get involved. So that's our first step, and we're going to launch that this fall. From there, we want to provide strategic expertise to people and organizations working on these issues, including, and I hope increasingly so as we go forward, legal technology companies and justice tech companies working in the access to justice space. And I define, I know the Justice Tech Association has a definition, wonderful association. I'm pleased to be on their board. But I define access to justice a bit different. That would be technologies that empower lawyers to provide services and other providers to provide services to people in a way that is passing on the cost to individuals. We know we have a lot of legal technology out there now that is being used to make more money for providers, but not necessarily being passed on to the consumer by way of savings. So we want to empower those companies. So it's a bit of subject matter expertise and strategic expertise in this area of creating a broader ecosystem of justice reform.
So is this a stupid question? Is this a commercial endeavor? I mean, you how are you going to make money from this? Through the kind of consulting work that you're talking about, or?
Yes, we will do consulting, but it's important to me to self-fund, and Zach also to self-fund the scaling of this information that we know, that we hold close, that we know where it lives. We want to be able to put that out there for free. So we're thinking about a lot of content that people can use and leverage for free in order to keep the movement going and to add to the movement.
As you've heard, my guest Natalie Knowlton and her former ISLES colleague Zach Demiola, who was previously Director of Legal Education and the Legal Profession at ISLES, and who, by the way, was on an episode of this podcast last year discussing re-regulation of legal services, have just founded Access to Justice Ventures, a think tank devoted to reinventing the legal system with a focus in the near term on rebuilding the regulatory structure that limits legal services delivery to licensed lawyers. When we return, we'll talk in more depth about these regulatory reform issues, including what evidence there is that reform will enhance access to justice. But first, let's hear about the sponsors whose generosity supports LawNext. Chasing late payments shouldn't be a consistent part of your day. That's why Meriscase now offers Meris Pay, the easy-to-use, compliant payments processor that's built right into the platform. Now, your firm can accept online payments directly through Meriscase, which is where you already manage everything else related to your workers' compensation, employment and labor, or insurance defense cases. You need a resource that works for you in the background. Learn how Meriscase can support your practice at Meriscase.com. That's MERUSCASE.com. Welcome back to LawNext. As we return to the conversation with Natalie Knowlton, who has spent the bulk of her career studying the empirical evidence for what works and what doesn't in the justice system. We'll dive deeper into some of the most pressing issues we face, including regulatory reform, broader licensing of paraprofessionals, court reform, and ways to close the justice gap. And we'll also hear about Natalie's vision for what the future of legal might look like. So let's get back to it. When you talk about, obviously you're going to be focusing on regulatory reform. Given the fact that you've been looking at this issue and studying this issue, what's the evidence out there that regulatory reform will make a difference or can make a difference?
That's
well, actually, let me just stop you there, just because for anybody who doesn't know what we're talking about. What are you talking
Sure.
about by regulatory reform? And then,
Okay, so the work that I've been involved in and others, when we talk about legal regulatory innovation, generally consists of some rules changes to the rules of professional conduct that govern lawyers. So this would include the big ticket items on my radar and Isles' radar are co-ownership issues, fee sharing issues in 5.4, and then unauthorized practice of law rules and how we might expand the ability for people who do not have a law license, to nevertheless provide some sort of limited legal services and legal advice to people. So
right,
that's
so co-ownership
predominantly,
meaning non-lawyers would be able to invest in and own or co-own
exactly,
enterprises of some kind that are delivering legal services.
absolutely.
Yeah.
So
And
what
so
evidence?
go ahead.
What does the evidence show? That's the big question.
Yeah.
So let me just start by saying that we have evidence on the status quo, and we know that that's not a maintainable status quo. That cannot continue to scale the way that it has. So that's evidence that we need to be trying new things. Now, are these particular rules the things to be trying? That's what the states are experimenting with. And when I talk about data-driven reform, I'm talking about collecting information on whether or not the harms that people have grave concerns are going to happen actually happen. So the California sandbox that recently was or soon will be defeated, the Utah sandbox that is currently operating, and many of the sandboxes in Canada are employing that risk-based framework and collecting data on that. So we know what actual harm looks like, and we can regulate based on actual harm, not perceived or assumptions that we have about the harm that's going to occur. So I think as regulatory reform innovators, we are doing what we can do to collect the data to show that the harm is not going to actualize. But I would challenge people who oppose this. What is evidence to show that we should not do these? What is the evidence that people have? And the answer is none, that this is really going to compromise public protection, because we've not been able to collect data on these issues. So I don't know that it's the golden ticket, but I know that collecting data on it is the way that we're going to answer that question. And so that's really what I've pushed for at Isles, what Isles certainly stands for in terms of data-driven regulation, and what we're going to be talking about at Access to Justice Ventures as well.
Yeah, and we're getting data out of Utah, and I assume we're getting data out of Arizona. I don't know if they're keeping data in the same way that Utah is. Are they doing that?
They are, I believe, keeping data on complaints, so that should be available. I don't know that they have the structured program, and I don't believe they do, but don't quote me on that. But anyone can visit their website and get more information just by looking at Arizona alternative legal structures.
But so the question I often get is kind of the flip side of that. Not how do we know it's not going to do harm, but how do we know it's going to do good? How do we know that this will, in fact, make a change in closing the justice gap over the long term?
Well, and that's what some of the researchers coming into the Utah program are looking at, is how do we measure that? I think access to justice and increasing access to justice is key over the long term. But I think it's very important to keep in mind that we're talking about market changes. They take a really long time, particularly when you're talking about a state like Utah, which is small, and we need to expand out to additional markets to really get an understanding of the full scale of these potential reforms. But in my definition of how we're knowing that these reforms are working and doing good is that they're just stopping potentially the decline. If we stop the decline of access, if we think about the LSC report, it was 86% of people don't have enough legal help, and that was 5 years ago. Now it's 92%. So we've got a decline. If we can stop the decline, then I'm okay with that in the short term. I think it's dangerous to look at and consider that we need evidence in the short term that access is increasing. If it's just not decreasing, then I think short-term wins have been had.
Yeah. Are you satisfied so far that the programs that are being approved as kind of alternative legal services providers in Utah's sandbox and in Arizona are the kinds of programs that could make a difference over the long term?
I think so. I think, look at RASA. RASA is working on expungement issues and certainly has the ability to scale to states nationwide that have clean slate laws. Some of the PI innovation that's coming out of Utah is very interesting. That's been a space that has been really controversial. As I know you had Joshua on recently from Mighty Law.
Schwadron, is that him? Yes.
Yes.
He was on this show, as a matter of fact, yeah.
Yes, that's right. That's right. And there's an individual in a firm in Utah doing similar work to that, trying to provide access to personal injury litigants who might not be able to afford the full thing, because access is still an issue, even if we have contingency fees. So I think the data is going to show the harm, and I'll go back to that. As long as we're not causing harm, I think that's a success. But certainly in the long term, if we can give it, I would even venture to say 10, 20 years of these types of new providers and new services and new products, then I think they will show demonstrable impact.
Yeah. I know that when a couple of years ago, or I guess it was, or whatever it was it that long ago that Utah and Arizona adopted these changes? There was talk, including on this podcast, of these being kind of the dominoes starting to fall, and that we were going to start to see more action all across the country towards regulatory reform. And yet now, as you alluded to, California's kind of put the brakes on efforts there for now. I don't think it's necessarily killed it in California, but it's certainly been a major obstacle to it moving forward. So, I mean, what do you think the likelihood is that we're going to start to see other states moving in the direction that Utah and Arizona have?
It's hard to tell. I do think we are talking to states across the country that are interested in this, that have yet to launch a formal task force or committee or a statement of interest in this. So the interest is definitely there. We're seeing, for example, in New Hampshire, the legislature got involved. So I think we're seeing some different models. I think involving legislators in understanding what's happening, what these reforms are, and how they can be of help is something that we learned from California, something that might have been done early on to avoid the kind of surprise gotcha interference that happened late in the game. But I'm optimistic, which is strange because I'm usually not optimistic, but I'm optimistic other states are going to move forward. And I'm not completely sold on the fact that, or what some people consider the fact that California has fallen and so the national reform is going to die. I don't necessarily think that California will have that kind of effect, but it remains to be seen.
Yeah, I tend to agree with you on that. I mean, I tend to think we are going to continue to see movement in this direction, but I wish we were seeing it a little more tangibly or moving a little bit more quickly than we have so far. Mm-hmm. One thing is the ownership issue. The other is the sort of the paraprofessional issue. I think, didn't Colorado just do something on paraprofessionals?
Colorado has a proposal out for public comment right now.
Yeah. I mean, that seems to be something that on one hand could move more quickly. The states are perhaps more open to. I don't know if you agree with that. But at the same time, there was the whole Washington state experience with the triple LTs that, they started up this whole program and then shut it down. I mean, do you think, what do you think about that approach of enabling a sort of a broader class of people to deliver limited legal services?
I think it's a great approach. I support that approach. I think you're absolutely right that states view that as less of a lightning rod than sandbox and ownership issues. We're seeing a lot of states that have been working on that. I know the Conference of Chief Justices and the Conference of State Court Administrators is talking about this particularly, these legal paraprofessional programs. ILS currently has a program run by my former colleague, Michael Holberg, Allied Legal Professionals, where he's compiling information on all of these proposals and existing programs. And ILS will convene a dialogue around what best practices might be and the limited research that we have and what it shows. Washington is always thrown around as this, well, why are we doing it? Washington failed, but Washington had flaws. Every program is going to have flaws. So the devil is not in the the theory of change. The devil is in the implementation of that. And that's where I think states are going to move forward quickly or fail. And I'd also note that it's not just, while I have looked at these kind of traditional paraprofessional programs in my career in regulatory innovation, and that's where I've been most active, there's entire tiers of providers, similar to that ecosystem we were talking about, that includes what Rohan and Upsolve are working with in New York, and the legal empowerment in the community space, social workers potentially. New York had a proposal out for that. So it's a tier, one tier of many, many tiers that we should be exploring, in my opinion.
Natalie, how critical is regulatory reform to the overall goal of closing the justice gap? I mean, if we don't achieve, widespread regulatory reform, can we still get there in terms of at least narrowing the justice gap?
It's a piece. Regulatory reform is a piece of a broader whole of solutions. So I don't know if we can get there in some respects if we don't have some of these changes, particularly in terms of the tiered providers. The medical system has found that to be incredibly useful. And there are any number of tiers that you'll see through the stage of a surgery or an illness. So I envision something like that being incredibly important for the U.S. justice gap. But it is just a piece of the puzzle. So we're talking also about court simplification. We're talking about self-help, community and legal empowerment. Pro bono legal aid are certainly pieces of that puzzle. So it's just a piece, but I think it's an important piece because we've spent some time with these other pieces, particularly legal aid, long history, pro bono, long history. The problem is still getting worse despite our efforts and our allocation of funding there. So while I'm not suggesting we stop funding, I'm suggesting that we stop just focusing on the solutions that have been tried over some time and work with new solutions too.
Yeah. It seems that, I don't even know if this is a question or a statement, but it seems one thing that seems very clear is that the organized bar in this country continues to be an obstacle toward some of these innovations. And obviously some of the recent vote from the ABA that made very clear that the ABA has no taste for reforming 5.4. Is just the latest example, but we've seen on the state level a lot of that the organized bar has been, again, a major speed bump or obstacle or something to reform. So I guess my question is, do you have any thoughts on how we change that or how we change that momentum and kind of get the bar to understand what's going on?
Well, I probably don't have as many thoughts as I would like to have because it continues to be an issue in many states. But Utah, for example, is a state where the bar and the court came together.
Yeah.
Now, I think many members of the Utah bar are probably still unhappy with the sandbox, and I know that there's some criticism floating about the work of the sandbox.
But it was the leadership of the Utah bar that was very instrumental in bringing about those changes. Yeah.
Right. And to be fair to California, it was the leadership there of the bar that I think prompted these initial exploratory efforts into legal regulatory reform. But there are certain components of the bar that are more vocal and active than others. And I don't know how, honestly, if I had a perfect world, we would all come together at a table because the organized bar and voicing the concerns that they have, they're concerns and they're valid concerns. We should be asking those questions. But we should be asking them as questions to one another and building a program that addresses these concerns, as opposed to just saying, well, my concerns are the reason that we can't move forward with this. So that's what I wish would happen. I think ILS potentially might be playing a role in that space moving forward. ILS has traditionally been a convener of diverse perspectives. So I think that's an organization and others. Stanford is working in this area, and I think they're convening and discussing with diverse perspectives and trying to bridge that gap. So I think more and more we can get everyone at a table together as opposed to being across the virtual aisle in a public hearing where we're giving comments and support or opposition, that would be a place to start. But I also think that we need to be aware that we're talking about breaking up a monopoly. There are real economic issues that come with that. Monopolies have traditionally been resisted. Or the efforts to break up a monopoly have traditionally been resisted by those who hold a monopoly. It's human nature. So we're kind of competing against that too, which is just something that we need to be aware of.
Yeah, I mean, you've been working on pulling together the evidence here. When you present lawyers with the kind of the empirical evidence around some of these issues, does that make a difference? Does that persuade them one way or the other?
It does not. It has not seemed to at this point. And that's a key thing to learn about data is that, and I can't remember the name of the author, but a famous change management leader who talks about how you need a burning platform to go with the data. So data is not just going to change minds. You need a reason behind that. And I think that reason is how lawyers can benefit from these changes and how lawyers can play a role in alleviating the concerns they have around these changes going into effect. But we as supporters of legal regulatory innovation probably need to be doing more to highlight the opportunities for lawyers. So lawyers can get onto that from a personal human being standpoint. What's in it for me? We all ask that question. And I think we need to be providing some of that data to lawyers as well as the data on the access to justice gap.
You referenced court simplification a few moments ago. What do courts need to be doing to make themselves more friendly, accessible, hospitable, I guess, to everybody, but in particular to unrepresented litigants?
First, I think it's a mindset change. Courts need to realize that it's their responsibility to help people access the system. It's a taxpayer-funded system. It's a piece of government. All people should be able to access it. And some courts have this mindset, though, that this system was designed for attorneys and only attorneys can go through it to serve as gatekeepers for their clients. So I've talked with a lot of courts who just say it's not our responsibility to provide these people with new processes, new information, and new providers. So we're not going to get into that space. But in those courts, the reality is that legal aid is just not doing the trick and pro bono is not doing the trick, and judges are getting more and more frustrated. So that's the first step, is it's kind of a cultural leadership, taking leadership on the issue. And then the second is figuring out what's been done and what works. So self-help centers, information online, there's kind of a tier, or I guess a progression of how courts would do this. And often courts put forms online that are incredibly difficult to get through. Nobody can understand them, but they're online. And this is where Lois Lupica talks both about accessibility. Where is it? Can I find it? And deployability. What do I do with it? So you have courts that are at that accessibility level. Let's put this information online. There you go. And then other courts that are bridging that deployability level. And this is where the work of Lois and Hallie J. Pope and those who are working in visual literacy really come into play in providing people with an understanding of what to do with the information that they have from the court. And then the more sophisticated courts have self-help programs, online programs where people can call and get help if they need it. So it is kind of a progression and a hierarchy of effort, but it takes that fundamental appreciation that it is the responsibility of courts to help people access justice.
Yeah, I always like the reference that Richard Susskind made in his book about reforming the courts. That you can't change the tires on a moving car, and the problem with the courts is that they're just so overwhelmed all the time and so short on resources that it's difficult for them to even think about some of these reforms, let alone implement them. Do you think? From what you've seen, did the pandemic make a difference in how courts are thinking about these issues, in particular thinking about maybe, using technology and using it in better ways to provide, to make themselves more accessible?
I think it did make a difference in terms of remote hearings in particular, and also in putting information online for people, which includes recording self-help tutorials and putting that online so people can access that. And that scales much better, obviously, because then it's not one-to-one in a self-help center. It's this one-to-many model that we know we need in order to scale access to justice. So I think that has helped. But of course, the backlog from courts being closed is overwhelming in some courts. I know a lot of tools are coming out to work on that. National Center has a tool they just released to help courts with backlog. So it both helped in terms of modernizing courts to implement technology that has been available in many other areas of the consumer experience. But I think it has highlighted that the current model of justice in the court system is not scalable. The process, the requirements, same thing with the broader legal system in terms of legal services. It just was not a model designed to scale the needs that we have today.
I love on your LinkedIn profile, you describe yourself as engaged in succession planning for an outdated legal industry.
Yes.
What does version 2.0 of the legal industry look like, or whatever version that would be? I mean, what's your kind of wish list for how the legal industry should change or evolve?
I think
a big question.
Yeah, it is. And I'm sure I have the wrong answers, but that's why I work with so many brilliant people together. We'll all figure it out at some point. But I think courts and justice is going to start looking a lot more like community solutions. Courts are already getting into this pre-filing type of mediation or ODR in some instances. I think we're going to start seeing more of that to expand out the jurisdiction of courts to help in a more preventative manner before it gets to this extreme dispute that you have to go to trial to solve. I think we're going to start seeing more partnerships across courts and other providers in the community. Stacey Mars in Alaska has done this amazing justice map, where the courts in rural communities can offer self-help information to police officers and libraries and those leaders in the community that are out there but not associated with the court directly, so that people can find justice and find court-related information in the community. I think we're going to start seeing partnerships in a more formal sense, medical legal partnerships where hospitals and doctors are helping resolve some or helping move to resolution some legal issues that they can. So I think it's going to look a lot more like a community working together for justice and a lot less like a single institution in the courts working for that.
And, if you could come up with a plan for how we get there, how do we get there? I mean, we've talked a lot about regulatory reform, and obviously, as you said, that's part of it. But how do we get from where we are to where we should be?
Well, we need the two types of people in the reform space, the systemic reformers who are up here looking at data, looking at systems thinking, and then the providers who are on the ground working with clients every day. We need all of those, both those groups, a lot of people from both those groups coming together to share experiences and share journeys. We need to be involving the customer. We need to be involving other providers in how people can play a role. The big thing that I would like to change, and we're going to be doing some of this with Access to Justice, is moving the conversation away from just what can lawyers and judges and those in the system do to what can others. What can we learn from the medical profession? What can we learn from disparate professions that maybe on its face don't have any similarities with the legal system, but when our systemic problems are abstracted, they do have some insights for how we can work on that. So I would like to see broader dialogue with different disciplines and communities coming together, the systemic reformers and the doers on the ground. We all need to be working together to envision this. It's not going to be one person that has that succession plan. It's an industry effort.
Right. Is there top of your head? Is there an example of that, of something where something we could learn from another profession or another vertical that would be applicable to this problem?
Well, just because I haven't done a lot of the research into other verticals, I'll fall back on the one that we always talk about, and that's the medical industry. And we do see such a change in the medical industry once tiered providers were able to provide help, and it has become such a ingrained piece of what it's like to go to the doctor, what it's like to be a consumer of medical care. You don't assume you're going to see your surgeon when you go in to get your stitches out. You know you're going to see a nurse, and nobody thinks twice about whether that nurse is qualified. It's just become ingrained that these different providers can serve us. And so I think that is a great example of where law should be going. Also allows attorneys to work at the highest level of their skill and expertise.
So I've been peppering you with questions, and what else would you like listeners to know, either about the work that you're doing or about the broader issues that you're tackling here?
Well, it's hard work, and a lot of people, I think, appreciate that, and we can get really down on the potential for innovation and for fast-moving results. So it's certainly not an industry to get into if you don't like delayed gratification, but keep up the good work if you're in this space. And I'm always interested in hearing from people, especially interested in hearing from people who disagree with me on these things. I would love to start creating dialogues around how we can work together to create systems that allow us to gather information while the public is being protected, but that also allows attorneys and other providers to scale services, make money because we need to support our families, and really help the access to justice issue more broadly. So please contact me if you want to talk or have any questions or want to learn more or want to tell me why you disagree. I'm totally open to hearing that. And then just a thank you to everyone working in this space, even, opponents who are organized opponents to these efforts are still doing incredible work on the ground. And I think that needs to be acknowledged. And the one commonality that we all seem to have is that we're really passionate about this industry. We really think that law is critical for people to access and that attorneys have such a role to play in leading the succession planning for our industry. So thank you to everyone, even if we disagree on things, for what you do.
Yeah. Do you hear from, I mean, you're out there on social media and whatever, do you hear from people who disagree with you now?
I do. I do hear from people, but I wouldn't say it's in the most structured or organized or productive fashion. Right. And part of that's on me too, in the way that I engage. And so I need to work on that. And with Access to Justice Ventures, we're going to be doing some of that as well.
Yeah, good. Well, Natalie, congratulations on launching this new, to you and Zach both, on launching this new venture. And thank you so much for taking the time to speak with me today.
Thank you so much for having me. It's been a dream to be on your show, so I really appreciate it. It's
been a dream to have you on the show, so I appreciate it. Stay well. Thanks.
You too. Thank you.
My sincere thanks to Natalie Knowlton for taking the time to speak with me today. What are your thoughts on today's show? Share them by tweeting us at LawNext Podcast. LawNext is produced, engineered, and edited by Populous Radio. I'm your host, Bob Ambrogin. I hope you'll join us again next time for another episode of LawNext.